first case is case 18-2361. It is the case of IT versus DCF and the guardian ad litem. Counsel, would you like to reserve any time?
Yes, 3 minutes, Your Honor, for rebuttal.
Okay. Thank you.
May it please the court, Richard Joyce on behalf of the mother, IT, who has appealed the termination of her parental rights to 4 of her children. The termination, she seeks reversal on all 4 grounds. The trial court terminated her parental rights to 4 children in 2 separate final judgments under 39.8061C, which is irrespective of services, 39.8061E, which is failure to substantially comply with the case plan, 39.8061E3, which is that the children were out of care for 12 to 22 months, and also the last one, 39.8061L, which is that on 3 occasions, one child or another child has been removed from the parent's care. I have challenged the constitutionality as applied of 39.8061L as to this case, because there was only 1 removal of each of the children. Although there were 5 children removed from the mother's care, they were all removed just 1 time. And the statute is very explicit that it states in its clear language that it's a child or another child. What the department did in its petition, or a second amended petition for termination of parental rights, and what the trial court followed, was they took a total...
Well, counsel, do we really need to address the constitutional challenge if the plain text of the statute implies a different meaning?
The constitutionality as applied...
Right, I know you're challenging the constitutionality,
right,
but you're making the argument, and you made the argument in your brief, that a textual reading of the statute renders a different result than that was engaged by the trial court, correct?
Correct.
Okay, so your position is that if we read the statute plainly, the statute calls for the fact that there would be separate removals as opposed to a single removal that was effected on different dates, right?
Correct. It would be multiple removals of the same child, as the 2 cases to which I cited to NB, but that was a facial constitutionality challenge. And the other case that everybody seems to rely on is KJ. Judge Hawks, in his opinion, stated that it was multiple removals. The statute itself is set up for multiple removals of 1 child, not a total of all the removals of separate children at one point in time.
Right, because the department could always remove children on different days when there were multiple children, which would automatically give rise to a statutory basis for termination.
No, I don't believe so, because the way the statute's written, the way I would look at it is that 1 child has to be removed 3 or more times. As Judge Hawks said, it was repetitive behaviors. We don't have repetitive behaviors here. Essentially, there was 1 incident by the mother, the allegations of neglect, and also the allegation of abuse against the oldest child, who was not even, the mother's rights were not even terminated to her. She was placed with her father. And then they removed 3 of the children at one time in December of 2015. Then they found DMT, removed him in 2016, and then when IV was born in 2017, they removed her. But the removal for DMT and removal for IV were based upon the mother's first actions.
Let me take you back just a moment so that I can be very clear as to the record in the case.
Okay.
Because as I understand it, the reason the department got involved is because the older child had a bruise on her face, which the mother admitted to striking her, correct?
Correct.
And the allegations of neglect that were founded at the children whose the termination of parental rights are at issue here were that one of the children seems to be a little listless in attending school and not attending school regularly, right?
Correct.
Were there other allegations of neglect that predated the shelter hearing in the case?
Not that I am aware of.
So here the department is seeking essentially the culminating event was that a child was not regularly attending school.
Yes, Your Honor.
Okay, so that is why the parental rights, that's how we've arrived here today. Where a mother's parental rights, her right to parent her children, is going to be terminated because her child was not regularly in school.
And, Your Honor, that is correct. What happened was when she came in and she had the case plan, what they said is she never gained insight. She didn't complete her case plan at the time of the manner.
Well, that's a factual dispute in the record because there are different evaluations that were rendered on different dates, some of which say she was making progress, some of which say she wasn't making progress. Some say she was gaining insight, some said she wasn't, correct?
Correct.
Okay. All right.
So as to 39806(1)C, I challenge the irrespective of services. The trial court relied on Dr. DiTomaso's evaluation, which was done in 2016. The trial was in 2018. He had not reevaluated her between that time, and he was there opining based upon pure speculation that she couldn't parent.
In the context, oh, sorry, go ahead.
Didn't he in fact review a report that had been completed in 2017?
Yes, he did. He reviewed Dr. Klein's report.
And he was in a position to review, and it's nothing inappropriate of him making comments with respect to what he got from that report.
Right, but essentially his opinion came down to pure speculation. It was, I told you so, and it happened. Dr. Klein's opinion, he didn't agree with it completely, but yes, you're correct.
As a matter
That
of
he
fact,
could rely on that and present his evidence.
and he articulated that he's not going to opine with speculation because he hadn't seen her recently. He did say that himself during the hearing.
Yes, but the trial court relied significantly on Dr. DiTomaso's opinion to render its final judgments. And the final judgments were very interesting because at the last day of the trial court judge immediately terminated parental rights to DMT and to IV, the two younger children. But then she said, I want to wait and see about the two older children, one of whom was the other child that had the school situation was NS and CS. She rendered the first final judgment on September 28th, and the second final judgment was on October 18th. Basically, they're mirror images of what there was no further considerations. If you have no other questions, I'll finish with my arguments.
Well, in the context of the staleness of evaluations, I know you relied heavily in your brief on the staleness of evaluations. In the context of, for example, involuntary commitment of sexual predators under the Jimmy Rice Act,
right.
And in some incompetency context, there is case law that dictates that a staleness is a consideration that the court should take into account. Did you come across any research that would reveal that in the context of terminating parental rights, staleness is a consideration?
No, I did not, Your Honor. And I specifically used the Jimmy Rice and the adjudication of incapacity because they deal with fundamental liberty interest, which are dealing with here was a fundamental liberty interest because the mother is losing the parental rights to her children. Now, we filed, and I'm not going to go into argument, but I filed a notice of supplemental authority based upon the new opinion that came out of the Supreme Court, now establishing Daubert as the procedural mechanism for the admission of evidence.
I have a procedural question to ask you within the file. When I was reviewing the lower court record in this case, I noticed that an order was entered retroactively several months by the trial court. And it was a significant order within the record because originally the trial court had ordered that dyadic therapy be transferred to Kentucky. We all know the mother had some housing stability issues that were dictated by economics, as well as a job loss. She relocated eventually to Kentucky to work for Amazon and to live with her brother and to set up a residence where her children could live. Purportedly, the brother and sister-in-law were willing to have all the children come live there, and there were suitable arrangements, but there was never a home inspection conducted by the Department of Children and Families in Kentucky, and the dyadic therapy was never transferred. Do you know, I believe it was a 4-month delay in the signing of the order by the trial court that issued the continuation of the case plan. Do you know why that delay was there?
I do not, Your Honor, because I didn't come into this case until the appellate level, but I would just have to assume that the order wasn't done in a timely manner because...
So how could the mother be on notice? Because it was a nunc-pro-tunc order.
That is true, Your Honor. I mean, the situation was her attorney was in there, or she had a very capable trial attorney that would argue continuously. In my discussions with her, she was aware of the situation, but I think she made her objections to the fact that in the trial court below, that the fact that the orders were being entered at such a time was prejudicial to the mother because of the situation. She was trying to better herself. She did have financial problems. If the transcript and the final judgment are looked at closely, it's all about housing and source of income. The court was concerned about they couldn't figure out where a source of income was being derived from. So, as you said, she moved out of state to try and better herself, found appropriate housing with a relative where she could have taken her children in. However, the children are now scattered about, with 3 of the 4 with relatives, and then 1 was with a non-relative.
There was sexual abuse in the record that was identified. Did that occur while the child was in placement with the paternal foster family?
That came up at a later date, and the mother successfully completed the class for the sexual abuse of children for
non-offenders
parents.
Well, it indicated that it happened at the hands of her cousin, so I was curious as to whether or not that came up while she was in paternal family placement. Okay.
It did.
Okay.
I'm not sure about that, Your Honor.
Counsel, real quickly, what is your best case on the your argument that the trial court abused its discretion by allowing in the stale report? Is it the O'Reilly case?
I would say so, Your Honor, or the it's escaping me now, the other one. But the bottom line is that you're dealing with a fundamental liberty interest. You're essentially bringing it in, having a psychologist come in and say, yes, it's because of what she did, she just proved what I said she wasn't going to be able to do. And it would.
But if we're going to find, which you're suggesting, that as a matter of law, a trial court abuses its discretion by allowing in a report that's 18 months old, what is the yardstick?
Well, the yardstick, I would say, go back to right, but the bottom line is that if it's an abuse of discretion, now, what judge would consider something that's so untimely? Now, I know Judge Shandon mentioned that he reviewed Dr. Klein's opinion, but he relied heavily on his own opinion based upon his report. He admitted that he didn't do a subsequent evaluation of her or any interview with her. So at that point in time, with O'Reilly being the fact that it was a stale report, that there has to be something there where, I mean, once again, we're dealing with fundamental liberty interest at this point in time. How can you deal with as a matter of law, how can you deal with a report from 18, 16 months ago now to determine what the mother is going to happen? Because the termination of parental rights, similar to like the Jimmy Rice, is all prospective. In Jimmy Rice, they prospectively believe that this individual is not going to be able to recover and redeem himself, be rehabilitated, and put back into the community. With the termination of parental rights cases under 39806(1)C, 39806(1)E, and 39806(1)L, they're all prospective. There's not like there's been actual harm to a child like under 39806(1)F where it's egregious harm. It's all prospective looking. So I would say if the yardstick, if you're talking about, if we're looking at a yardstick for prospective actions or inactions by a parent when you're attacking a fundamental liberty interest of the parent to be a parent of a child, I would say that you have to have a very current evaluation.
What is that? What is 3 months?
I would say 3 months or right before the trial. But here, at least after this mother had engaged in services, here the doctor started, well, he did the evaluation 10 months in. There were some services started, but the bulk of the services the mother completed after that. And he had no opportunity to evaluate her at that time. I don't even know if the department even asked him to evaluate her. They just liked the report that they had from prior years, and they had him opine as to that when he testified.
Counsel, wasn't the doctor aware of the fact that the mother had not helped facilitate the home visits that could never take place because she would never contact the agency so they can appropriately do the home visit? And there were several other failings the mother had.
Yes, there were some failings the mother had.
The doctor was aware of that when he testified.
The doctor was aware of that, but when he started off and he made his recommendation for services, he made certain recommendations for services. He made recommendations for servants for substance abuse evaluation. She completed that. They made the evaluation, the parenting class. She completed that. And I understand what Your Honor is saying. He was provided more information, whether it was provided at the trial during the adjudicatory hearing or beforehand, and he reviewed it. He did have that beforehand. Yes, but it was based upon what he was reading. He was essentially based upon reading other documents. He had no firsthand knowledge.
As an expert, he has the ability to do that.
Yes, he does. But I would say that he was so clouded by the report to begin with that he was trying to essentially bolster his own opinion from the beginning. And I think that and I understand why he might do it, but I would say in a context where you're dealing with a fundamental liberty interest, I don't think a trial court should be permitted to rely on something from a couple, 16 months, 15 months ago, then have the doctor testify to it and provide more facts. I understand completely what you're saying about an expert. I understand that the trial court attorney objected, said that there was a more current opinion of another psychologist. It was not used. It was she did not testify. I do not know why, but
In your supplemental authority, you raised the renewed, now Florida standard of Daubert, but this doctor's testimony would have been admissible under Frye or Daubert.
I don't believe it would have been it would have been admitted under Daubert, and because I don't think that they met the requirements, and since it's procedural, and at that point in time Frye was applicable, I am pretty sure that if the trial attorney knew that the Daubert standard applies, she would have moved for a Daubert hearing in a timely fashion. And I don't believe that it can, even based upon the supplemental authority that the department submitted, Perez and Bell South, the doctor's opinion is essentially pure speculation. It's not based on any scientific measurement or evaluation. It's just, as you stated, he's reading documents and he's giving an opinion of another doctor's opinion of the mother, having not read it, and he's trying to bolster his own opinion from before she even engaged fully in services.
Counsel, we brought you way over, but we will give you a couple minutes
thank you.
for rebuttal. I understand that the department and the guardian ad litem would like to split their time.
That's correct, Your Honor. Laura Lee with the Guardian Ad Litem program. We'd like to split our allotted time equally.
Okay.
May it please the court? Laura
You may
Lee on
proceed.
behalf. Thank you, Your Honor. Laura Lee on behalf of the appellee, the Guardian Ad Litem. Your Honors, with respect to Section 39806(1)(c), there are two issues being raised. The mother initially raised the relevance of Dr. DiTomaso's testimony and report in her briefing. And with her notice of supplemental authority, she's seeking to raise at this time an argument about the reliability of that testimony under Daubert. With respect to the Daubert challenge, although at the time of trial, Florida law in general may have been in flux about whether Daubert or Frye applied, this court made it quite clear in 2014 and 2016 in the Perez and Rojas cases that I submitted as supplemental authority that this court was applying Daubert. Therefore, the mother's failure to make a Daubert objection based on reliability results in waiver in this court. With respect to the relevance argument, the staleness of Dr. DiTomaso's report goes to the weight of the evidence, not its admissibility. And importantly, the cases cited by appellant with the Jimmy Rice Act and the competence of the defendant issues, those cases required a finding as to the party's status at the time of trial. Under the C ground, with respect to the futility of services, it necessarily looks back in time. Why would services be futile? Have services been provided in the past?
Let me interject for a moment. Isn't the starting point in any termination of parental rights case a demonstration that the continuing involvement in the parent-child relationship threatens the life, safety, well-being, or physical, mental, or emotional health of the children?
Yes, Your Honor.
Okay, so here, the series of events that have given rise to why we're here today is that a child who's not at issue in this case had a bruise on her face because she was struck in the face by her mother, which does not constitute the abuse under Florida law as a matter of law by several appellate decisions that is specified within that standard. And then you have a child who sporadically did not go to school as regularly as they should, right? That's how we arrived here today, right?
That was the initial shelter.
Okay, so that's how social services got involved, because a child didn't go to school.
Correct.
Regular. Okay. So, and these children are at varying ages, and the mother had them for the older children for the majority of their childhood without incident, without social service involvement, without harm to them. And we're here at a termination proceeding where the trial court relied upon 3 separate removals that were a single removal effected on different dates, and a failure to substantially comply with a case plan where the mother purportedly became homeless and moved to another state because she was told she couldn't get her kids back unless she went to get a job and housing, which she did obtain, but it was in another state, and obviously there's a lack of resources to fly back to Miami, which was evidenced by the record. And an evaluation that was conducted at the outset that says she's not amenable to services, which is belied by the evaluations that are in the record saying she's making significant progress. Do you have any problems with the chronology by which we're here today?
No, Your Honor. The record also, I'm not sure if we're breaking up.
I can hear you. I can hear you.
Okay,
Thank you
thank
for checking.
The record also reflects that prior to the case coming into care, the mother had left NS and CS with a relative for an extended period of time. The record reflects the mother's continuing instability in employment, in not being forthcoming with the department about her employment situation, telling different stories about her housing situation. Indeed, the second removal involving the child DT, who was actually named on the first shelter petition, didn't occur until 6 weeks after the first removal of the other children because the mother had absconded with him to Puerto Rico. So there's competent, substantial evidence to support the termination here based on the overall conduct of the mother since December, even prior to December of 2015 when the case came into care. But in terms of the relevance of Dr. DiTomaso's report, it's important to note that he was very clear in his testimony that he wasn't saying, he made a prognosis in 2016 that the prognosis was poor. He also recommended services. The mother was given services, and the court made factual findings based on the evidence that the mother had failed to comply, failed to remedy the circumstances that brought the children into care, was still unstable. Indeed, when she moved to Kentucky, she didn't even tell the older children that she was leaving. And then in terms of the dyadic therapy orders, the dyadic therapist testified that you really couldn't do remote dyadic therapy because the parent and child need to be in the same place. The mother moved to Kentucky. I believe it was North Carolina she was also living in for a while, and then she told the case manager she was planning to go to Texas. So the department made more than reasonable efforts to, work with the mom.
The department did not transfer the dyadic therapy to Kentucky. The court entered a retroactive order dated 3 or 4 months before, indicating that dyadic therapy should have been transferred to Kentucky. The record contains no explanation as to the delay in the execution of the order. And then everything became at a very rapid pace to terminate parental rights rather than to transfer dyadic therapy to Kentucky. Since the goal is reunification, the goal in these proceedings is not to terminate parental rights. It's to reunify the parent and child and to make services available. I know you had a grim prognosis at the outset with the evaluation, the one evaluation that was obtained, but this is really analogous to LAG versus Department of Children and Families at 963 Southern 2nd 725, where Judge Shepard concurred and talked about the entire goal. You can't just say that a parent lacks insight. The department's role is to offer services that will give insight to that parent because there is a presumption of reunification. So if the services were not transferred to Kentucky despite court order, how could the mother have been given every opportunity to substantially comply with the services.
Your Honor, I would agree that the first goal, as stated by the legislature, is reunification. And I would argue that the record reflects the department engaged in reasonable efforts to help this mother reunify with her children. The dyadic therapy was one part of the case plan. A lack of
She finished
insight.
everything else. She did everything else except for the dyadic therapy. She did it. She went
She
to
did.
everything else.
But the court found that she hadn't benefited from those services. The definition of substantial compliance in Section 39 requires more than just attending services. It requires benefiting from those services so that you can demonstrate that your children can be safely reunified with you. In this case, the mother never even achieved unsupervised visitation. So the dyadic therapy, although there may have been a mishap with the court's order, again, the dyadic therapist testified that it really couldn't be done, remotely anyway. The children were in Florida. Mom had chosen to move a couple of times, then told the case manager she was going somewhere else. So under those circumstances, the department did make reasonable efforts here.
Well, there's a recommendation that she begin unsupervised visitation with the children and she begin doing homework with the children. And several of the evaluations evinced that she was making progress, contrary to the department's position in the TPR case.
There was conflicting evidence, that's true, Your Honor, but it was up to the trial court as the finder of fact to make credibility determinations and to weigh that evidence. And its findings are supported by the record. If I may, I would like to briefly address the L ground that counsel brought up.
You may want to make it fairly quick because your colleague, you don't want to take up all of her time.
Thank you, Your Honor. I will be brief. The legislature determined that children are harmed when their parents engage in repetitive bad behavior necessitating their removal. That occurred here. The legislature was within its authority to enact Section 806.1L as a narrowly tailored means of protecting children from that harm. In the instant case, by the time the baby IV was born, the mother had not made any significant progress. The children had been living in the instability and uncertainty created by the continued disruption of the family, and that's the harm that the legislature sought to prevent. NSCS, DT, and IV are currently in pre-adoptive placements awaiting permanency. I would request this court affirm the lower court's order terminating the mother's parental rights under any or all of the 4 separate statutory grounds the court found were proved so that they can achieve that permanency. Thank you.
Thank you, counsel. We'll now hear from the department, your co-appellee.
May it please the court, Carla Perkins for the department. In reference to Judge Miller's question about the basis for the termination, the emergency shelter proceeding was just that, a shelter proceeding where the actual case begins with the order of adjudication. In this case, the exhibits reflect on pages 256 to 264 that on May 16, 2016, the court adjudicated the children NL, CS, NS, and DMT dependent upon mother's consent. And this is what mother consented to. She consented to findings that she had physically abused NL, who was actually placed with a father, so she was not part of the termination proceeding.
Well, she struck NL in the face, right? She struck NL in the face. And there's a panoply of case law throughout the state that indicates that that is insufficient as a matter of law to constitute abuse.
In spite of that, the mother did consent. I'm sorry. In spite of that, the mother did consent. However, NL is not part of the termination proceedings, so the mother's rights to NL were not terminated.
Understood. I'm looking at the procedural posture in which we arrived at this case because the underlying allegations of abuse and neglect are minimal at best. What you have is a situation where there was perhaps corporal punishment inflicted that does not rise to the level of abuse as defined by the statute, and you have what's been characterized as neglect by a child failing to attend school as regularly as they should, and a situation where children were left with relatives, but they were placed with relatives in supervision, and the case law does not support the fact that that's neglect.
I understand the court's concern. However, that may have been part of the shelter proceeding, but it was not part of the order of adjudication, because the order of adjudication did focus on, it not only focused on the physical abuse, but it also focused on the mother's unstable housing. She had abandoned and neglected NL, CS, and NS. Regarding DMT, mother pled to testing positive for oxycodone a few days prior to DMT's birth and fleeing to Puerto Rico.
It was prescribed, though, by a doctor. when she was pregnant. The doctor prescribed it to her. That was uncontroverted, correct?
Okay, but she actually pled to this, and this is what the order of adjudication was based on. So a case plan is actually developed based on what the court finds in terms of adjudicating the children dependent. So when the courts, when services are being provided to the mother, they focus on what the order of adjudication indicates. And here you had a number of different things where a mother had abandoned the children, she had neglected the children, and there were issues of maybe substance abuse. So the case plan development actually tailors the services.
Wait. Hold on 1 second. There were no issues of substance abuse. She took a prescription from her physician, and that is why she tested positive, and she was subsequently underwent a substance abuse treatment and evaluation, and they said she had no substance abuse issue, and both of the psychologists testified to the same, correct? Because we're lumping things together. We really need to look at the facts. You're saying she abandoned the children. The abandonment that you're talking about is during the case plan, which is her failure to visit with them when she relocated to Kentucky. And the substance abuse that you're talking about was not diagnosed within the record. They said she didn't have a substance abuse issue, but nonetheless, they had her go to substance abuse counseling in an abundance of caution.
They did.
Because it sounds very inflammatory when you're saying it. But when we really cut through the record, what we have here is somebody who struck her child in the face and then left children with relatives, and the other child did not attend school regularly, or as regularly as they should. It was silent in the record as to how many days.
The child not going to school was not a basis for the termination of mother's parental rights. It was not. The case plan, again, which is provided the services for the mother, focused on what the order of adjudication found in terms of what mother needs to remedy the circumstances in order to be reunited with her children. So what you have is you have mother being asked to attend dyadic therapy, and that was, and Ms. Marquez, the therapist, testified to the fact that the therapy was to increase mother's bond with her children, and mother was doing well. However, mother left the state of Florida without even saying goodbye to her children. And you have two case managers who testified to their multiple attempts to perform home studies requested by mother. The former case manager, Ms. Hernandez, testified, and she was on the case from 2015 to March of 2018. She testified that mother actually requested home studies. Mother had a home in Homestead. From January of 2018 to March of 2018, the case manager and her supervisor went twice to the premises to conduct the home study. No one answered the door. The other case manager, who was the current one, also testified to mother requesting a home study after March of 2018. Then when she asked for further contact for the mother to verify the date, mother then sent another text that she had moved, and when they went to the home, other people were living in there. No other request for a home study was done again. The problem in the case...
She became homeless. She became homeless. She went and tried to get services, and she was placed on a waiting list for a shelter. And under the statute, you can't terminate for economic reasons.
The case here is not one that indicates it was for economic reasons, because the case managers also testified. The first case manager testified mother never even informed them of a problem with housing. The second case manager testified the mother asked for another home study. So mother, if she was having issues, was not forthcoming with the issues. Just as mother left the state of Florida and did not even tell her children that she was leaving, mother's actions are, as Dr. DiTomaso, whose evaluation, while it may have been back in 2016, the facts are he testified in his evaluation was that mother has an IQ of 70. The IQ cannot change. He said that mother is self-focused. The evidence before the court was mother is self-focused. Mother left. Mother said she was moving to one state. Mother indicated she wanted to move to another state. Mother testified at trial she's willing to come back to Florida. Mother also testified that her family there in Kentucky is willing to have the children there. So you have testimony all over the place. Where's the stability for the children? Where did she testify that she is providing? Initially when she left, the case manager said initially when mother left, she contacted frequently for the first week. After that, mother's inquiry about the well-being of the children dropped off. Mother complains of different issues, but she has a case manager that she can communicate with, that she can find out what, how, where are the children, are they well? She dropped off. The interest of the mother dropped off because the mother is self-focused. Mother is in another state, mother has her job, and mother's priority is herself. It's not her children. In terms of...
Counsel, you've run up against your time here, and so we're going to hear a rebuttal from the appellant now. Thank you, Ms. Perkins.
Thank you, Judge. We ask that the court affirm.
Thank you, Your Honor. Richard Joyce again on behalf of the mother, and I apologize before I misspoke about O'Reilly. For some reason, I thought it was an involuntary civil commitment. It was a competency to proceed, and what I will say, upon further review of the case and my notes on it, yes, it is because the case itself looked at LeWinter and didn't like the fact that and relied on LeWinter and said that was a 6-week-old competency, not a competency, but an incompetent proceeding where they did an evaluation. So I say if you look at that case and place it to this situation, it's got to be less than 6 weeks old. Whatever that yardstick is, I would say within a month. You mentioned 3 months before, but I would have to retract it. And once again, I apologize for that, Your Honor. I believe you are correct. DCF and the guardian ad litem in their arguments are trying to shift the burden back to the mother. The burden is on the department. It is the agency, the state of Florida, that's trying to intrude into the mother's fundamental liberty interest and trying to take her children away. The mother entered consent plea. She did not admit to anything. She entered into a consent. She did all her services. The only thing was dyadic, and as Your Honor said, it didn't take effect. For that, I would request that Your Honors reverse termination of the mother's parental rights to all 4 children and remand it to the trial court for further proceedings. Thank you.
Thank you, counsel.